We are live.
Good.
Good morning, everybody. We're about to start our seminar on ethical practice during the COVID-19 pandemic. And I'm Jim McCauley, Ethics Counsel at the Virginia State Bar. With me today is Katie Uston, an Assistant Bar Counsel, and Seth Guggenheim, an Assistant Ethics Counsel. And today we're going to discuss a number of different topics or issues involving legal ethics and practicing law during the COVID-19 pandemic. Katie, why don't you say a few introductory remarks about yourself, and then Seth will follow.
Okay, thank you, Jim, and welcome everyone to this program. We are hopeful that this will be useful to folks as we all navigate this very unusual time we find ourselves in. As Jim indicated, my name is Katie Uston, and I am an assistant bar counsel with the Virginia State Bar, where I've been serving for the past 14 years. I also am an adjunct professor at the American University Washington College of Law, and I think that's probably sufficient for the time being. And I'm just
Okay, thank you, Katie. Seth?
I'm Seth Guggenheim. I've been with the Virginia State Bar since February of 2000. Initially, I was a prosecutor for the bar as an assistant bar counsel and then senior assistant bar counsel, and I did that for 12 years. I migrated to Jim's department, the ethics department, in April of 2012, and I've been there since. We in ethics man the hotline. We help the ethics committee generate legal ethics opinions for ultimate approval by the Virginia Supreme Court. And we are on the seminar circuit giving ethics lectures and so forth. And all of us in the ethics department regularly do that. And it's one of the things that we enjoy the most. I was in private practice for 20 years before, until 1997. Then I went to what is now the District of Columbia Attorney General's office. I was there for a while, and from that position, I moved to the Virginia State Bar, and it's a wonderful place to work, and I love the work that we do, and it's very necessary, especially in the ethics department, where we can give advice to Virginia practitioners so that we can keep them out of trouble and answer their ethics questions when they're confronted by a dilemma.
Okay, very good. Let's get started. There was a recent survey by a management team at Fastcase revealing that 87% of the respondents in a survey indicated that they had shifted from their office into working out of their home. And so a lot of our comments are going to be involved with that aspect of lawyers practicing in the pandemic. But I thought it was interesting that so quickly lawyers are making the adaptation of using technology to work out of their home. I know it presents some challenges, but we need to talk a little bit about the ethics rules and how that interplays with the pandemic. So, the overarching concept that I want to focus on is that the rules of professional conduct do have some elasticity in terms of how we apply them and how we adapt them. The rules by no means can cover all of our ethical obligations. Some of our ethical obligations are intuitive, but others not so much. They can be counterintuitive. The preamble to the rules of professional conduct indicate that these are rules of reason. The rules that govern ethical practice have to be reasonable. And you'll see the word reasonable throughout all the rules of professional conduct and the comments, reiterating again that we can't let perfection be the enemy of the good. We have to do our jobs. We have to represent our clients competently, and lawyers can practice ethically and competently during the pandemic. using reasonable care to reduce their risks of spreading the virus to others or becoming infected themselves. I want to talk a little bit about competence. Competence is the first rule that we encounter in the rules of professional conduct, Rule 1.1. It is a critical and fundamental ethical requirement. What does competence mean in the pandemic? Well, first and foremost, it means that we should be checking with the courts in which we practice to find out what's open, what limitations or restrictions are in place. If you just rely exclusively on the now third emergency order that has been entered by the court, you would learn that the courts are generally suspending criminal and civil cases. Yet on the other hand, some courts are trying to use technology to conduct hearings and get beyond merely bail review hearings, protective orders and such, where the court has indicated that those types of matters can be heard, notwithstanding the governor's order and the court's order suspending the courts. But it's important to check local court practices and procedures to find out how they are adapting. And there's you'll see on this slide the link to the court's website, and I would check that every day to find out if anything is changing. The beauty about this particular site is it has all the courts. So if you're practicing in Henrico County, you can check through that website and find out information about what Henrico County courts are doing, whether it's a general district court, circuit court, or JDR. So that's important. Secondly, part of being competent is setting up your office space so that you can continue to practice law, that you can interview or contact clients and intake new clients. Most importantly, how are you going to collect money? Are you using credit cards? Do you have a trust account system in place? Can you do your record keeping and procedures for handling money remotely? The survey that I spoke about, the FAST case survey, indicated that the most significant problem that lawyers and law firms are having right now with the pandemic is financial stability. And it's very important that we try as best as we can to have financial stability so that we can be comfortable and be at ease with our practice. Now, we're going to turn next to the topic of communication, and I think that takes us to Katie.
Yeah,
or Seth.
Yeah, I'm going to address that, Jim. Thank you. Communication Rule 1.4 is actually a very short rule which has 3 sections to it. It reads, a lawyer shall keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. And the 3rd section, which is letter C, says, a lawyer shall inform the client of facts pertinent to the matter and of communications from another party that may significantly affect settlement or resolution of the matter. And then there's a series of comments which follow the rule. The communication is something that lawyers sometimes get into trouble for not really performing adequately. A great number of the bar complaints that we receive at the Virginia State Bar deal with failures of not only diligence, but of communication. A client will leave a series of phone messages and maybe write a letter and they're seeking information about their case. And lawyers sometimes fall down. They feel that they don't have enough to really communicate, or don't feel like telling the client something a second or third time, and so on and so forth. But it's very important. You don't have to, you're not going to get into trouble for not returning every single call or answering every single letter. But clients do need to be kept abreast of what's going on in their cases. And sometimes there are long hiatuses in a case that are occasioned by the type of case it is. An immigration matter, you might have to wait months or years before something happens in the case. A personal injury case, you don't need to speak to the client every single day because nothing has really changed. The client's still being treated, and so on and so forth. So, this, as Jim said in the preamble, these are rules of reason. So just because a client tries to communicate with you doesn't mean that you have to be a super big hand holder. But it is very important, especially right now with this pandemic, because clients are incredibly nervous about, whether they can get into court, how they're going to get into court, what the electronics might be that are involved, if there's going to be a hearing, and so on and so forth. So right now there's an enhanced obligation, I would say, to stay in touch with clients, because the court procedures are changing. I'm a member of the Alexandria Bar Association, and every single day it seems that I get a little ping in my email, and the Bar Association is sending out the latest adjustment to the court procedures, and so on and so forth. And while Jim said you can go to a website and find all the court procedures there, which is certainly valuable, it is a good thing to also see if your local bar association can't keep you updated. And when you get updated, it's important to update the clients about, any new date that they might be able to have their hearing on, or their matter attended to, if it's a court-related matter, and so forth. So it's very important to tell clients how you will be handling their matters in view of your perhaps working at home, or teleworking, or whatever it is you're doing. Let the clients know where you are, how to contact you, and tell them that every time something significant happens in their case, you're going to keep them abreast, and more so now during a time when it's critical that a nervous client be calmed down, that everything's under control. You're familiar with the court procedures. You're going to tell the clients what the court procedures are, and so forth. There are, during this judicial emergency, there are going to be cases that are continued. And a lot of what your client was expecting when he or she first came in to engage you will not pan out to be the way you explained it pre-pandemic. So you have to let the clients know that your advice is being adjusted. Now, under Rule 1.2, you as a lawyer are in charge of the means of representation, even though the client is in charge of the objectives of representation. So the means of representation do include things such as scheduling, and so on and so forth. So you're not really approaching the client for permission to continue a matter that needs to be continued based on the present circumstances, or because the court insists on a continuance. That is within your prerogative, but you do have to keep the client informed of important dates and what it is that might be delaying their case. It's not your fault things are being delayed. It's not a lack of diligence on your part under Rule 1.3 to get to something. You just can't get to certain things because of the way the court schedules have been adjusted based on this emergency. The bulleted point here, prioritizing client matters. I think most lawyers are pretty good at that. They deal with what's urgent first, and what's less urgent second, and what's not at all urgent third. And that's something that comes naturally to most lawyers. Scheduling and rescheduling, re-entry plan when judicial emergency is over, to the extent that you can be informed by the court as to how things are going to be handled once the court opens up as fully as it can. You need to tell your client about that. It's important that the client know the best timeline for his or her matter that you're handling that you can come up with based on the information that you're receiving. So that's what I have to say about communication.
And thank you, Seth. And I just add that particularly during this pandemic, a lot of people are insecure, and clients are going to be more anxious than they've ever been. And so it's important as part of your communication duties to use messaging and use your website and blogs and other tools to keep the clients generally aware of what's going on in the courts where you practice, and to have a system set up where you can at least acknowledge that they called and let them know that you will get back in touch with them as soon as possible. Another thing I might add is that if you haven't already been considering this is an opportune moment to consider going to a virtual law office and establishing an internet portal like many doctors and medical practices have, which generate the capability of the client being able to connect with you and to receive assurances from your office that things are working as normally and well as they can under these trying times.
Yeah, Jim, that's an excellent series of points that you just made, and I will emphasize that you may be sitting home as a lawyer, not able to go out and do what you normally do. But think of your clients. They're also, many of them, not allowed to go to work. They're not in essential services. They are sitting at home. And what are they sitting at home thinking about? Their legal matter. So the volume of inquiries that you will be getting from clients will probably go up, per client under circumstances such as this. And while Rule 1.4 doesn't require excessive hand-holding, you're not going to be disciplined if you told the client something once and you're not going to tell them something a second time that you just told them the day before. But be attentive to the fact that clients are going to be jittery, nervous, have a lot of time on their hands, and be focused more than they would normally be focused on their legal matter if they had a business day to contend with, which was normal and distracted them. So it's very important to be attentive to communication.
It also is important when you're having those communications to don't just launch immediately into the legal issues or the legal problems, but to have some sort of empathetic rapport with the client, find out how they're doing, how their families are doing, how they're coping during these times, so that you establish a good rapport, and also helps to reduce the anxiety and tension that this pandemic has created for all of us. Remember, many folks are cooped up in their homes. They have children that they're trying to home teach while maintaining a full-time job, and then they've got legal issues that are causing anxiety. And so it's very important to have empathy and compassion with your clients.
Jim, that's an excellent point, and it reminds me when I've been on the hotline since this pandemic started and the stay-at-home orders have been in place. The first 3 to 5 minutes of many of the hotline inquiries that are handled on the phone are, how are you? How are you coping? What are you doing? And the lawyers are telling us what their workarounds have been, and all that, and they want to talk about this. This is a common plight that affects all of us, and I think it's a bonding experience when you're able to share your own experiences with those of practicing lawyers. And if you are a practicing lawyer, share those experiences with your clients, not just your friends, and it will form a very nice bond between yourself and your client.
That's true, very true. And while we're talking about communications with their clients, we want to talk now about securing the confidentiality of those communications so that there is not a loss of attorney-client privilege, and so that also that we don't breach our ethical obligations under Rule 1.6. Katie, do you want to walk us through this topic?
Absolutely, I'm happy to do it. Before getting to 1.6, I did want to make a couple of observations about the subject matter that we have just discussed just now, including
Certainly.
competence, communication, etc. With regard to competence, which Jim discussed at the outset of the program, there is also a comment to Rule of Professional Conduct 1.1 that speaks to the issue of if one is not competent in a particular area, or if one does not feel that he or she is competent in a particular area, achieving proficiency is something that is okay under the rules. And where we find ourselves now with this very unusual circumstance involving this virus and the pandemic and the lockdown, many lawyers that I have been speaking to are getting questions about things that they really don't have any clue about. And while one might in other times refer that client to someone else or decline to address those issues, in the current situation in which we find ourselves, that may not be an option. So I wanted to point out that the rules do have some leeway for attorneys who may not feel proficient in a particular topic or subject area to achieve that proficiency and be able to then advise their clients as to things that might come up that they've never encountered before. I also wanted to make note of the fact that as people find themselves at home, it is still necessary and required that Rule of Professional Conduct 1.15, which pertains to the deposit of trust funds, deposit of client monies into trust, be complied with. And if your bank is not offering mobile deposits, that presents a challenge. But naturally, that rule continues in full force and effect and has to be something that attorneys keep at the forefront of their minds, because client funds must go into trust. And the pandemic is not going to have any implication or not. It's not going to change that rule at all. I wanted to make one other point, and that is with regard to a client's inability to pay. As Seth observed previously, many folks are out of work, and many of our clients don't work on a salaried basis. They work on an hourly basis, and it may well be that some of your clients simply don't have any income and they're not able to pay. Obviously, that works a hardship to attorneys, and attorneys are not required to work for free. And so if it is necessary to withdraw because the client cannot pay you, in this unusual situation in which we find ourselves, it seems that a little compassion and willingness to help someone who is not able to pay probably is something to consider. But as I note, nobody has to work for free. And if you do find that you must withdraw, of course, that must be done in such a way so that there is, and the rules specifically speak to this issue, that there is no harm or prejudice to the client. And it brings up another point, and that is that if you have to seek leave of court to withdraw, that may be something you're not able to do, because some courts are not scheduling matters like that. They're not scheduling things that are not emergencies. So I wanted to point that out too, because I know that that is something that folks are also grappling with. With regard to confidence, client confidences, the applicable Rule of Professional Conduct is 1.6. And that rule, obviously, I think folks are pretty well familiar with it, if not the exact way the rule itself reads, with the overarching principle, which is it is our duty to protect our clients' confidences. Now we find ourselves in a situation where some people are working literally at the kitchen table. Ideally, moving your law practice home would involve you moving your law practice into an office or other dedicated space in your home that you can use exclusively and you can have to yourself, and folks won't be coming in and out and looking over at your files laying around or overhearing conversations. So ideally, that would be the best way, the best practice to establish a home law firm, because that's what so many folks are now finding themselves having to do. However, that may not be possible. Some attorneys may find that they literally do have to work at the kitchen table. If that is the case. And if you have to be in a space, if you have to conduct your practice from a space that does have traffic, does have other people coming in and out, your kids, your spouse, folks who live in your home with you and who are quarantining with you, then it is very important to take reasonable measures to ensure that the confidentiality of your files and of your conversations and of the work that you are doing is maintained. And one suggestion that I have with regard to files, if you have to spread your things out on a table that is used by others at other points in the day, when you are finished working on a case, it sort of is kind of contrary perhaps to the way folks do things in their offices, where you can leave files on your desk, you can leave papers open because you know you're going to get right back to it tomorrow and you don't want to lose your place. But in this situation, it would be very important to make sure you close everything up, put things away, put them in.
Also, the dog could end up eating your homework, and that's not good.
Literally, quite literally. So put things away at the end of the day, put files away when you're finished with them. It may be inconvenient from the standpoint of having to pull everything back out again the following day, but it is important to do. With regard to client phone calls, again, if you're unable to have a dedicated space, take the calls in another room. Just take the phone and go into your kid's bedroom and shut the door and tell them they can't come in until you're finished. That's really important. And it's not something that's necessarily intuitive. But even though you may be dealing with family members, of course, who you trust, and they're not going to run off and report what it is, whose matter you're working on and who was recently charged with DUI or whatever the case may be. Nevertheless, one never knows how something might come up in a conversation subsequently. And also, it is important for your clients to know that you're taking these measures and these precautions, because that will help them feel, as Seth indicated, previously, it's important to make them feel comfortable as well. And that will help them to feel comfortable and know that you are taking account of what is important to them. And that is that that their confidences be protected. Now, there's another less intuitive step that is very important to take, and that is if anybody has in their home the home assistants, Alexa, Google Assist, those types of things. We all know now that they listen, and those should be turned off, or any conversations that you have about your case or phone calls that you're taking should then, if you can't turn it off or if your family won't let you turn it off, need to be done outside of the hearing capacity of those types of virtual assistants. And then again, with regard to internet access, sticking with technological challenges, unfortunately, what we have seen in this crisis, what we have seen in this pandemic, is that sadly, very sadly, there's a proliferation of people who are, or I should say bad actors. There's a proliferation of scams. There's a proliferation of people attempting to hack into law firms, title companies. They're taking advantage of what is viewed as a weakness. And so, speaking to the issue of internet access, it's never been more important than now to ensure that you do not use public Wi-Fi when you are doing your banking, or when you are communicating with your clients over a network that Jim mentioned earlier. If you have a portal, it is critically important that there be a protected, secure network that you're using in order to carry out those very important tasks that are the tasks that you need to do in order to continue your practice. It's not a bad idea to consider a VPN. I'm not a technology person, so I actually don't know what's involved in that. And if it creates a great expense, I don't know. I can't speak to that. But if possible, that would be the best option. If it is not possible or cost prohibitive, then obviously, if at all possible, have a dedicated network to your law work. And again, if that is not possible, ensure that you have security on the network that you are using and that your neighbors don't share your Wi-Fi network or whatever the case may be.
You can create privacy on the network by adjusting the settings so it's not So other neighbors that are using Verizon or Comcast, when they open up their network, they won't see you because you've adjusted the settings. It's also important. Sharon Nelson and John Simic say this quite often, to make sure that you change the password on the router and develop a strong password for that. Don't use the one that's on the label of the machine, so that you have better security. Password controlled. Also, the VPN, the Cisco product is what the Virginia State Bar had been using before we moved to Citrix. It's not expensive. What it does do is it limits the people that can be on that network to only those persons that have the credentials to access the system. It's password controlled. And it's a very effective way to prevent hacking and interference. Also, Zoom. A lot of lawyers are using Zoom to conference with their clients, other attorneys, staff, and so forth. And there's been some negative reviews about Zoom and what they call Zoom bombing. Before it was photo bombing, now it's Zoom bombing, where unauthorized third parties could jump in on your communications. There are other teleconferencing platforms besides Zoom, but I do want to say that there are a number of articles out there, and Sharon Nelson and John Simic are doing a CLE program on how you can use Zoom and make it secure, again by using conference numbers. I know that some of us, I'm sure now all of us, have used different types of platforms like WebEx and Zoom, GoToMeeting, Google GoToMeeting, and if left in their default settings, they're not secure. But if you go in and learn about the platform and the software and adjust the privacy settings, you can have secure, confidential communications with your clients and your colleagues.
Yeah. So one final point that I would like to make with regard to the issue of confidentiality, et cetera, is what I have been hearing from colleagues concerning how they are, folks in law firm settings, how they are continuing or attempting to continue to have some degree of normalcy as they all now work from home. Some law firms, because the legal resources are considered to be an essential service, and so they are not mandated to be closed. And so many law firms are open but utilizing a skeleton staff. Only one or two of the lawyers go in. They alternate days. Administrative staff may or may not be coming in. All of this is just something that law firms themselves are deciding what works best for them. But one thing that seems to be universal in terms of being an effective tool are weekly team meetings, similar to the one we are doing now, where everybody's face is displayed in a square on the computer, and you're able then to see your colleagues, interact with your colleagues, and we're going to talk about wellness later. And that is something that can help with what otherwise could be a very isolating situation. And the other important aspect of considering taking that step of having a meeting with your colleagues on a weekly basis or something like that is that it also will help you stay on top of your own case files. Because one thing that we tell folks all the time, and that is absolutely the case, is that what will end up generating a complaint to the Virginia State Bar is a client who's not being attended to, a client who's being ignored. And it is a completely natural human tendency to not call the client back whose matter you haven't gotten to yet. And then it just gets worse and worse and spirals from there. And so having a meeting with your partner or with your associate, or even with just your secretary if you're a sole practitioner, to review the calendar, to review upcoming dates and deadlines, to review the most recent orders issued by the Supreme Court and by your local courts where you practice, to look at your ticklers, what's coming up. Those types of things will help keep your cases flowing and moving as they as you know, as much as is possible under the circumstances. And my final point is that there may come a point at which, as well, given if you are very limited in your resources and limited in your ability to continue to practice in this current setting, you may have to refer some clients out. And although that is a financial hit, unfortunately, it's something to consider very seriously. If you are just simply unable to attend to a client's matter, then they may need to be referred to another colleague or law firm that have better resources so that they can take over the case and go from there. So that's it. Thanks, Jim.
All right, Katie. And before we move into topic 5 on contingency planning and backup, I wanted to emphasize that there are some good resources out there for developing your practice working out of your home. Most notably, I would recommend visiting the website. The ABA's Coronavirus Task Force has resources. Videos are uploaded on YouTube that deal with navigating the pandemic in your practice, leveraging technology to practice law, what types of equipment and tech and software you need to conduct a law practice remotely, with specific recommendations, how to use Zoom for teleconferencing and still be compliant with your ethical duty of confidentiality. We're going to have, with the written materials, the links to these resources so that you can have a good toolkit for operating a law office out of your home. And we'll point you to those resources in the written materials. Let's go on to contingency planning and backup. Seth?
Thank you, Jim. Contingency planning and backup comes under the rubric most often of succession planning. Lawyers can, as every human being can, be besieged by accidents, debilitating illnesses, diagnoses of terminal conditions, and so on and so forth. And a lawyer who, especially in a small firm or as a solo practitioner, it's very, very important to ask yourself the question, if something happened to me today, how would my clients be cared for? How would my clients' matters go to the next step that they need to go to in my absence? And far too few lawyers have succession plans when they should have succession plans. And that calls for, in some instances, the Virginia State Bar to step in and have a circuit court appoint a receiver so that the receiver can go into the office of the deceased or disabled attorney and try to make some sense out of what the files are and contact all the clients, offer to return their files to them, notify them of potentially critical upcoming dates. The receivers don't themselves practice law, but
they don't work for free either.
And they don't work for free. That's correct. And those expenses, while they may be advanced by the Virginia State Bar, do become the obligation of the attorney whose practice is subject to the receivership. It could be a debt of the attorney's estate. It could result in severely negative impacts on the lawyer's family's inheritances and so forth if the bar has to be paid back for what it has advanced on behalf of, for the benefit of the receiver. So that's one thing which, it should be motivation enough that a lawyer would want his or her client's matters to be handled should something happen to the lawyer. But if that's not a sufficient motivator, the fact that it could be a very expensive proposition for the estate of the lawyer, or if the lawyer has passed away, or the lawyer himself or herself, if it's a disability situation. I'm pleased to say that the Virginia State Bar has truly excellent materials on its website on the issue of succession planning. Well, as Jim indicated, there's going to be a link in the written materials for this presentation. If you just wanted to quickly get to where you need to be on succession planning, you can go on the VSB website, and in the search window in the upper right-hand corner, just type the words succession plan and press search, and you will come up with a publication called Planning Ahead, Protecting Your Client's Interests in the Event of Your Disability or Death. And this goes through step by step the sorts of things that you need to do. And it also has some downloadable templates for forms that can be used in creating a succession plan. Basically what you need to do is make sure that there's some attorney lined up who can step in and, try to take over the cases if with the client consent, if that's what's necessary or advisable, or distribute the files and, supervise the disposition of unearned fees that are in trust, and make sure that the client's needs are, in the short term, accommodated in some way, including, helping them find a new lawyer. One of the very most important things that has to be considered here is access to the trust account. Banking institutions are very conservative. They will not take an attorney's trust account and treat it as though it's an asset of the attorney's estate. So a personal representative is not there to administer a trust account. It's not an asset of the lawyer's estate. And it's very important that there be another signatory on your trust account. It doesn't have to be a lawyer. The signatory could be a trusted secretary or non-lawyer assistant. Has to be somebody trustworthy. And that person should be instructed if it comes to pass that you pass away or you're disabled and the trust account needs to be accessed. It should be taken care of under the supervision of a lawyer. A lay person should not be making judgments about client refunds and so on and so forth. That they would need to be supervised by a lawyer. Some years ago, a very prominent, well-organized, extremely well thought of bankruptcy attorney in Prince William County passed away completely unexpectedly at age 61. And all of his files were perfectly organized. He had a wonderful office staff, but there was no way that his trust account could be accessed. And the Virginia State Bar had to establish a receivership for the sole purpose of having the court appoint a receiver who would be authorized to access the lawyer's trust account. And none of that would have been necessary. The inconvenience, the delay, none of it would have been necessary had the lawyer had someone authorized to sign trust account checks. That the clients could have easily been refunded their money virtually instantly if that existed. The lawyer's affairs and books were in excellent shape, and there were maybe 12 or 15 clients that were due refunds of unearned fees that were in trust, and the receiver was able to determine to the penny and with great ease who should get the money and what the amount should be, and he was able to write those 15 checks and give them to the clients. But the circuit court had to get involved because there was no signatory on the trust account. So it's very important that that particular detail be attended to. And that's easy enough to accomplish without the need for any kind of powers of attorney and so forth. No bank is interested in reading a 15-page power of attorney and trying to determine if the person holding the power is authorized to sign a trust check. The assistant branch managers are not really into that. They'll tell you to sit down, and they'll call legal counsel in North Carolina and tell you that you have to come back later because they haven't heard anything yet. So, signature card, authorized signatory, That's the way to go. And the stuff on the website is excellent, as I mentioned, and it's got very good tips. It's checklists, sample forms, and so forth. You should make sure, to have a succession plan is fine, but people need to know about it. So your succession plan documents should be in the hands of the people who need them, or they should be informed of where they can be found if something should happen to you. What you don't want is last minute scrambling of your survivors or people who are trying to assist you at a time when you're totally incapacitated and disabled. You don't want them to have to scramble to try to find these documents. You should acquaint everybody with their existence and their whereabouts.
And don't forget your user IDs and passwords
exactly
on your computer, so that they can access client files and records and trust accounts and operating accounts and so forth. Everything that we do now is user ID and password controlled. So they have to know how to get into these things. And so you need to talk to somebody and lay this all out, preferably give them a written copy of your succession plan and what it entails, when it's going to be triggered, particularly with this pandemic, because God help us if any one of us becomes ill by the coronavirus, you could be hospitalized for 30 days. I just read an account of a very avid athlete and skier and runner. Was in excellent shape, but it nearly died from it at age 47. And fortunately, he survived, but he was on a ventilator for 2 weeks. This virus could take us out for a while. So that would be a triggering event for your succession plan.
That's true. And that's a very good point, Jim. And on this topic, there's a little unrelated thing which I would like to comment upon. And, just as this virus may take you out, it may also disable your clients for periods of time. Mm-hmm. And I saw an excellent CLE where the presenter was suggesting that if there's a decision that your client needs to make concerning his or her case, and it can be made in advance of the actual moment where it needs to be made, find out from the client. Say, you might, I'm handling this personal injury case, goodness knows what's going to happen to me or to you. Let's talk about, what you will authorize me to settle this case for in the event that an offer comes in and negotiations begin at a time when you're not available to talk to me and to approve the settlement or whatever. Authorize, give me authority in advance of the time that I might otherwise ask for it, given the present circumstances where any of us at any moment could be afflicted in a way that we become unavailable. So, think about getting authority from your client for matters that need the client's authority under Rule 1.2. Try to get it in advance of the time that you might absolutely need it, so that if the client is unavailable at a subsequent time when the matter is ripe for resolution, you already have that authority. And of course, you should confirm it with the client in writing or by email or whatever format you need to do it, so that it's clear that the client has authorized you to do what it is you ultimately did when the client was not available to bless what the client has previously let you do. So that's just a little offshoot on this issue of succession planning. But please visit our website for excellent materials on that subject.
Very good, Seth. And you still have the microphone, so we're going to move on to our next topic. We want to talk a little bit about conflicts of interest in the context of this pandemic environment we're operating in.
Yes. None of the rules of professional conduct are suspended or abated or non-operational because of this pandemic. We may have to do things differently than we've done before in terms of the mechanics of practice and the timing of our cases and so forth. But conflicts of interest need to be checked. They just need to be checked as you would check them if you were sitting in your own physical brick and mortar office with a secretary nearby and an associate down the hallway and so on and so forth. Even if you're not the one who's primarily responsible for conflicts checking in your firm, you do have to have a direct line to the person who is responsible, so that if a call comes in, a prospective client wants to talk to you on the phone, wants to send you documents, and so on and so forth, you can clear you can clear that prospective client as being someone as to whom you would not have a conflict to meet with. And it's very, very important that you have access to the database, or that one of your assistants, be it a lawyer or a non-lawyer assistant, has access if you don't, so that the conflicts check can be performed. The informality of practicing out of your home does not mean that you have flexibility or are entitled to be lax when it comes to conflicts checking. That is as important a matter whether you're working at home or you're not, whether there's a pandemic or there's not. Very, very important that you not take a case that you shouldn't be taking, or even doing an intake of a case that you shouldn't be, because you already have a client under roof as to whom there would be a conflict. So very, very important that your conflicts checking mechanisms and programs that you've always used continue to be used, even if it's a little clunkier than it would be with a brick and mortar office. You still have to get your non-lawyer assistants on the phone or communicate with them by email and have these conflicts checked out. The rules are not relaxed at all on this subject based on the pandemic.
Okay, we are ready to move into next topic here, which is the scope of the representation. Katie, how is the scope of the representation affected, or what ethical considerations do we need to reflect on during the pandemic as it relates to defining the attorney-client relationship? Well, what lawyers can do, what lawyers cannot do, and so forth.
Sorry, I just dropped my pen. Thank you, Jim. And actually, Seth, I think pretty well discussed this issue just a moment ago concerning how Rule of Professional Conduct 1.2 has application in this current situation in which we all find ourselves. Specifically, as Seth mentioned, the client is the one who will define the objectives of the representation. They come to you and they say, this is what I want you to do for me. This is why I am hiring you. And obviously the attorney then uses his or her skill and knowledge and experience to map out the means by which those objectives will be obtained or sought. And as Seth noted, there may come a point at which, while the case is ongoing, that your client is unable to give you a decision on something that needs to be decided upon at a subsequent point that was not discussed during the first intake meeting. And they may be unable to do so. So again, as Seth mentioned, it's not a bad idea if you can right now take a little bit of time to sit down with the caseload that you have and come up with, try to predict what might be coming down the road and what you might need to have your client think about and decide upon now. Obviously, that can change if it doesn't come to pass that you're unable to consult with your client down the road when the issue does arise, because they may have a different decision at that point, or other factors may come into play that will change the decision. But it's not a bad idea to begin to try to map out what the future is going to look like. Matrimonial cases come to mind as an area where that is something that would be very beneficial to discuss, because all kinds of issues come up in those cases as they unfold. And again, as Seth noted, put it in writing, confirm it in an email, and it's not a bad idea to also indicate that you understand and realize and accept that there may come a point at which in the future, when these issues come up, if the client is capable of discussing with you, that obviously that is exactly what you will do. But in the event that they are unable to you're unable to reach them or speak with them, that you at least have considered these issues. If your client does fall ill, there's also a rule pertaining to 1.14 pertaining to a client with impairment that may have application. The upshot of the rule is that you should continue to handle the matter as though your client did not have an impairment, is not unable to assist in the representation. Continue to treat that client as you normally would to the best of your ability. But these are unusual times, and so every case is going to be different, and that is why the ethics hotline is such a critical tool, especially now for folks who need some input as to what to do under what might otherwise be a situation that you never imagined you would have found yourself in. I think that covers it, Jim.
Okay, Katie, thank you. To talk a little bit about civility and professionalism during the pandemic. There are stories abound of lawyer incivility in many other non-pandemic situations, but the pandemic brings us with a number of situations where lawyers need some empathy and compassion in dealing with opposing parties, witnesses, and counsel. There are instances where lawyers are insisting that depositions be taken in person, but the other side wants to do a deposition remotely and use an e-notary, for example, to administer oaths to the deponent before they're examined by counsel. There are other situations too where lawyers may refuse to give extensions on responses to discovery, are not amenable to continuing a deposition, and insist on holding opposing counsel to a date that they had agreed upon before the outbreak or before the pandemic. And the problem there is that we have to recognize that everybody is different, and some of us have pre-existing health conditions that no matter what our age may be, that we cannot take unreasonable risks in going out in public, and that we should all be patient with each other and recognize that we all have different limitations. That doesn't mean professionalism and courtesy doesn't mean that you sacrifice the client's goals and objectives. There are some things that we simply can't agree to. There was a recent case by the Supreme Court involving a plaintiff that had obtained a default judgment. The reason why the defendant was in default is because it was a corporate entity, and the registered agent did not get the papers to the company and from the company to their attorney in a timely manner, and it resulted in the plaintiff moving for a default judgment. And then defense counsel appeared on the scene and contacted plaintiff's counsel and asked plaintiff's counsel to sign an order granting leave to file a late answer, and the plaintiff's attorney said no. And the defense attorney said, well, that's outrageous. That's a very, very unprofessional conduct. I've never seen anything like that in my 20 years of practice. Continuances should be liberally granted. And I heard the oral argument in that case, and particularly where Chief Justice Lemons was asking questions of the defense counsel. What about the plaintiff's obligation to obtain the client's consent under these circumstances. You were going to make them go through a full-blown trial after they had obtained a default judgment. And, there's a difference between professionalism and the difference between Rule 1.3, which requires that lawyers act with diligence and carry out the objectives of the client. And if the client is resistant to a continuance because it would cause prejudice to the client and added expense in having to reopen a default judgment and go through a full-blown trial, that's not being uncivil or unprofessional when a lawyer adheres to the client's goals and objectives and abides by the client's instructions. So it is important to differentiate between civility and professional courtesy on the one hand and sacrificing or prejudicing your client on the other. Does anybody have anything to add to that?
Well, that was an interesting case because the trial court sanctioned the lawyer for not consenting to the request for to vacate the default judgment and allow
That's right.
an answer to be filed. So I believe it reached the Supreme Court, not protecting the default, but it reached, I think it was an appeal
of the sanction.
And the Supreme Court said, if you have a litigative advantage that you've gained in a legitimate way by, lawyering, and this is in the interest of the client not to agree, professionalism doesn't trump competence and diligence. And this is as unpleasant as it may be for the defendant to be in this posture. The plaintiff's lawyer had no obligation to open the door for, the potential for a trial and so forth. So it was the appeal of the sanction, I believe, was how it reached the Supreme Court.
That's correct. Thank you for pointing that out.
Sure.
Katie, do you want to talk to us a little bit about wellness and occupational wellness and lawyer wellness?
Yes, sir.
Why don't you tell us a little bit about your involvement in that too? Because I know you played a key role in developing the task force recommendations on a national level, and also have been involved in the initiatives on the state level.
Yes. Thank you, Jim. And you're right, I have been involved in this issue for some time. By way of brief background, in August of 2017 now, the National Task Force on Lawyer Wellness released a report which was born from a very disturbing study released by the Betty Ford Hazelden, by a study done by Betty Ford Hazelden groups, which studied the alarming prevalence of alcoholism, substance abuse, and mental health disorders and issues, in the alarming prevalence of those particular ailments in the legal profession. In other words, attorneys are disproportionately represented in the population of people who suffer from alcoholism, who substance abuse, mental health problems. And the question was, what do we do? How do we address this? The terrible end result of much of that can be, and I know colleagues of mine have experienced, a suicide of a colleague. And that is something that is very devastating, not only to the family, but to the friends and to the legal profession as a whole. And the report issued in August of 2017 is on our website, the National Task Force Report, and it contains 42 specific recommendations as to how to help identify, deal with, and address specific issues that affect the wellness of our profession. And the report itself is divided into 4 different sections in terms of stakeholders: private law firms, public sector lawyers, the law students, and then, of course, the judiciary. And there are specific recommendations contained within those 42 recommendations that pertain to those 4 stakeholders. Chief Justice Lemons, our own Chief Justice, was a member of the National Task Force that developed and wrote and published that report. He then came back after the report was unveiled to Virginia and formed a committee here, of which Justice Mims, William Mims, was named chair. I served on that committee, and the purpose of our work was to take the National Task Force report, the 42 recommendations contained therein. Justice Mims and Chief Justice Lemons divided our committee into the 4 specific stakeholders: private law firms, public sector lawyers, law schools, judiciary. And we studied the National Task Force report, recommendations relevant to our subgroup, and then made recommendations, analyzed them as it pertains to practice in Virginia, and then made recommendations as to how they could be implemented here in Virginia most effectively. That report is also on our website. It is on the Virginia State Bar website and the Supreme Court's website. It's excellent. It's a great product, and it very thoroughly analyzes the issues as they pertain to practice here in Virginia. Subsequent to that, Len Heath, who took over as president of the Virginia State Bar the following year, formed a committee which took a much more granular look at these issues and said, okay, attorneys suffer from depression disproportionately to the general population. How is it that the practice of law can exacerbate that? How is it that the practice of law, what we do, can actually exacerbate those types of things? And we took a very granular look at those issues and came up with specific suggestions and resources, suggestions as to how to address the issues themselves, and then resources that folks can go to attempt to get help where needed, or meet with other lawyers who have the same issues that can help and be supportive and share their stories as to how they manage to rectify their own issues in their own lives. The other thing that grew out of all of this work was a significant expansion of what was once called Lawyers Helping Lawyers here in Virginia, and is now called the Judicial Lawyer Assistance Program, Judges and Lawyers Assistance Program, JLAP. The funding to expand JLAP in part comes from what now all lawyers see on their due statement, and that is an extra assessment of $30. It is a small price to pay, considering the work that these folks do on behalf of Virginia's lawyers, and it is phenomenal, really phenomenal, what they are able to accomplish and what they were able to accomplish with 1.5 staff members for so many years under the auspices of Lawyers Helping Lawyers. Finally, the recognition has taken place that LHL needed to be expanded and better funded, and now it has been, and they are establishing remote offices, satellite offices around the state. They're expanding the availability of personnel, folks who can come and help and reach out to lawyers as needed. There have been other rule changes that we have implemented here in Virginia that are all directed towards helping lawyers get the help that they need, including a rule now. Previously in professional regulation, anything pertaining to a case that comes into our office is confidential and we cannot share it with anyone, anything about it, until it becomes public, which is down the road. But if a case comes in now and we suspect that there may be some issue that an attorney might be having with substance abuse, alcohol abuse, mental health issues, we are now permitted under the rules to make a one-way referral to JLAP, to call and say, this might be an issue, this attorney may have an issue. Anything that happens after that, any actions that JLAP may take after that, don't come back to us. It's completely confidential. Everything that happens at JLAP is completely confidential and is not discussed with the bar in any way, shape, or form unless the attorney agrees to have it be discussed with the bar. But what this will allow us to do is, if we as bar prosecutors see an attorney that might need some help, we can help to intervene or seek to have intervention for that lawyer at a very early point in the process when that attorney comes to our attention. There are other rules changes that have been implemented, including a new comment to Rule 1.3, Rule of Professional Conduct 1.3, which is the rule that speaks to competence. An attorney must be competent. What the comment says is that in order to be competent, and this pertains directly to the situation we now find ourselves in with the lockdown and the quarantining, an attorney, in order to be competent, should also be paying attention to their own mental and physical health. You will never be prosecuted because you don't exercise. You will never be prosecuted because you suffer from a depression. And that's not the point. A comment is not a black letter rule. It's been put into the rules so that we can bring this conversation to the fore and we can remove the stigma attached with talking about it. Lawyers, we are hired to solve people's problems. We don't have problems ourselves. All too often, that is something that I hear and that I observe, and it's something that all of us, I think, in some respects, suffer from. That we are the ones who solve the problems. We can't be viewed as weak. We can't be viewed as needing help ourselves, and we want to take that sort of thinking out of the equation and remove the stigma and say, yes, if you seek mental health treatment, that's okay. That doesn't make you a bad lawyer. You're not going to be fired. You're not going to be prohibited from doing anything that you would otherwise be able to do simply because you're seeking to help yourself. And one of the other things that's happened here in Virginia is the application for the bar exam now has removed the question or rephrased the question pertaining to whether or not an applicant to sit for the bar has ever sought mental health treatment. That's a nationwide thing that is taking place, a nationwide trend. That question's being removed from applications because people don't want to be, we don't want to be seen, and bar examiners don't want to be seen as discouraging folks from seeking help that they might otherwise need and getting healthy. So with regard to where we now find ourselves, many people are isolated. And what is already a sedentary practice, a sedentary profession that we have, is even more so now, because you're not getting up out of your house and walking to your car and getting in your car and driving to your office or biking to your office or walking to your office and walking down the hall to see your colleagues and chat for a while, or grab somebody and take the elevator down and walk across the street to the coffee shop. None of that's happening. People are stuck in their homes, sitting at their desks. So the sedentary aspect of our profession has never been worse. And that's a problem. It's a problem mentally and it's a problem physically. So, suggestions along those lines are easy to imagine and to think of on your own. Get up every now and then, go for a walk, try to exercise, do these types of things to keep your mind and your body healthy. There's so many things flying around the internet now about folks saying, I'm going to weigh 100 to 400 pounds by the time this thing is over because all I do is eat. And that's true too. It's when you're sitting in your house and your kitchen is right around the corner and you're otherwise either bored or tired or frustrated, you're going to go in the kitchen. I know I do. And so what you can try to do is just be mindful of the fact that, if you do that every now and then, instead of getting a cookie, get an apple, just something like that. So these are very, sort of basic things, but I think important to point out and to talk about, because if you have the support of your colleagues and it's something that you discuss when you have your weekly meetings, what are you guys doing to, get exercise? What are you guys doing to keep your mind clear? How do you, when you find yourself in a frustrating position and there's no one around you, there's no one down the hall that you can go consult with and talk to and try to talk it out, how do you deal with it? And that's something that if you don't have a firm, if you're a sole practitioner, you can chat with a colleague about on the phone. I know these things sound really basic and simple, and I suppose they are, but as I mentioned just a moment ago, I do view, and the bar views it as very important to open these up for discussion, raise these issues so that folks will take a look at how their current practices are going in these weeks of quarantine and try to address some of the issues that may well impact an attorney's ability to competently practice because of all of the difficult circumstances in which we now all find ourselves. And I guess that's it, Jim. I think I've covered pretty much everything I wanted to cover on that topic.
You've done a very nice job.
Oh, I'm sorry. I wanted to reference one last thing. I apologize. If you go to the Virginia State Bar's website, I've already mentioned the fact that there are the reports available on the website. There are also other resources there that you can look to that could be of assistance in the event that you find that you need some information or another contact for something that might be specifically it might be an issue that you're specifically dealing with. Thanks, Jim. Sorry about that.
Oh, sure, Katie. You've done a wonderful job summarizing the lengthy history of our efforts to improve lawyer wellness and to give VJLAP the funding that it needs to work effectively to help impaired lawyers overcome their impairment, whether it's substance abuse, cognitive degeneration, or whatever keeps them from being the lawyer that they want to be. And we're very thankful to you and Chief Justice Lemons and Justice Mims and Len Heath and so many others that have rolled up their sleeves and I think have made Virginia the leader in the lawyer wellness movement in the United States.
That's absolutely true, Jim. And I'm glad you mentioned that because I wanted to also mention that something I'd forgotten, and that is that coming up is Wellness Week, and it's going to be the national task force of which I still am a member is rolling out Wellness Week, and you'll see lots of things hitting your inbox on this subject that's going to be happening here in Virginia. Obviously, it's going to be a little different now. It's not what we anticipated when we initially scheduled this and rolled it out, but it's coming up, and it's something that we want, across the nation to focus on. And really, actually, maybe in some ways, it couldn't have come at a better time.
Wow. Yeah, that's true. That's excellent. Oh, sorry about that. You need to go back to layoffs, furloughs, and notification to clients. This is a brief topic that occurred to me, and I wrote a very short column in the April issue of the Virginia Lawyer that the stress, obviously, of being told that we don't know how we're going to do without you, but we're going to try. I'm sorry, you're laid off. Dealing with that stress, may cause us to be blind to our obligations to our clients because we're thinking first and foremost about ourselves and our family and how we're going to financially provide for them. But it's important also to recognize Rule 5.8, which is a fairly recent rule that codifies some prior legal ethics opinions, which told lawyers that if you are primarily responsible for handling a client's matter and you leave the firm for whatever reason, whether you're moving to another firm or whether you're on furlough or whether you've been laid off, you owe a duty to communicate with your clients to inform them of that fact. Ideally, it should be a joint communication by you and the firm advising the client of your departure. That doesn't always work out because these situations are not always amicable, and there can be also disputes over which clients are going to migrate with the attorney when they leave a firm. I imagine typically in furlough cases, there's an expectation that attorney will return to the firm. But the firm also has an obligation to ensure that client matter is being attended to while the attorney that was handling that matter has been furloughed. And so it's also part of their obligation under Rule 1.3 to be diligent and to ensure that the attorney, the representation is carried out. The rule does require the lawyer to meet and confer with the firm regarding the notice letter that's sent out to the clients. But if they can't meet and confer or they can't get along, then each has a separate and independent communication obligation to that client. So I think that's about it for us as we come to the end of our program here. Are there any closing remarks or comments that anyone has?
No, Jim, other than to thank you for hosting this and doing such a great job. I think this was a good program. Thank you.
And just in closing briefly, I want also, Jim, thank you for moderating this, and hopefully this will provide some useful and helpful information to folks as we all go through this tough time. And I also, of course, want to wish everybody watching this at some point in the future, if you're watching this, stay safe and healthy.
As the sergeant on Hill Street Blues would say before sending the officers out on the street, be careful out there. Mm-hmm. So, well, we're going to sign off. Thank you, everybody. Thank you, Seth and Katie, for your wonderful contributions, and we'll be seeing you virtually soon. Take care.
Take care. Thank you.
Bye-bye.